We've talked about this a number of times. I want to be quick about this. But we've talked about how it's easy enough to look at offer, add it to acceptance, equals agreement, and we have the birth, the germination, the beginning of a contract. But in the real world, we don't have very many simple contracts. We go backwards and forwards, we negotiate, we bargain, and identifying where the offer is and where the acceptance is a really difficult thing to do. So basically we need to think about what happens when you can't unpack the discrete elements. And there are two kind of situations where that happens. Probably three actually. But firstly, there's where there's communications between the offer happening and the acceptance of that offer. So we've talked about that kind of communication and being able to differentiate it from a counter-offer when we talked about suppliers of information, so Harvey and Facey and those kind of cases. So we already know that if an offer's made and there's some kind of communication that's not an acceptance before any acceptance is made, we need to ask ourselves, is that a counter-offer? Because if it is, the original offer lapses and we open it up again. Or is it a request for further information or some other kind of communication that means the offer's still on foot? Another situation that is not at all uncommon commercially is the situation that arose in Butler and Excello case, which is in your casebook. And this is often referred to as the Battle of the Forms case. So essentially in this case, what we had is a buyer placing an order for something using their standard form purchase order, and the seller delivering that thing with its standard form delivery notice. The terms and conditions were basically similar but not identical. So there was no one thing that we could point to as being the offer or being the acceptance, and they were different from each other. So what happened in that case? We got Lord Denning. So he wasn't too worried about the fact there's 500 years of law beforehand that says we need an offer capable of acceptance on its terms, and anything that's different from that is a counter offer, and unpicking it that way, which I guess is a way that you could have unpicked it. What did he say? Do you remember? Go on, Jack.
I don't actually remember this particular one, but don't they synthesize the sort of elements of each form and try and find middle ground?
I think you do remember. So basically he said the better way to look at all the documents passing between the parties and glean from them, I love this glean, it's the vibe. Glean from them, or from the conduct of the parties, not just the documents, let's also look at what they do and work out whether they've reached agreement on the material points. Even though there might be differences between the forms and the conditions printed on the back of them, at the end of the day, if it looks like agreement, if it smells like agreement, if it quacks like agreement, then it's probably an agreement. What actually are we looking for here? We're looking for consensus ad idem. So what has happened, I really like the use of the word synthesize there, because what we've done up until this point is we've had this very algorithmic, analytical approach. We need an agreement. What's agreement made out of? The court says, well, agreement's got an offer and it's got an acceptance. And actually when we think about it, that acceptance needs to be communicated. And the offer by itself, it needs to be objectively seen to be an offer. And so we've created this kind of equation based out of this sort of analysis of what an agreement is. But then Denning has basically synthesised that and said, well, actually, at the end of the day, we know what agreement is. What we're really looking for is whether the parties have, if we can synthesise what it is they're doing. Now, a good transactional lawyer will be saying, hold on a minute, I don't like this uncertainty. I'm going to go and stop my client from going and operating this way. And having been general counsel of a busy company where marketing people in particular are hiding every letter that they write from the lawyers. Good luck to you. Yes, Jack?
Just in that context, how do you know that surely what's material for one party might not be material for another?
Great question. Did everybody hear? How do you know what's material to one party might not be material to the other party? How do you work that out? What do you reckon the courts would say?
You can look at the consistencies in both sets of
Consistencies in both will help you unpick it, but from a materiality, what materiality we really mean what's important. What's important to one party, so it might be really important to me as the vendor that I get paid within 30 days of delivery. It might be really important to me as the purchaser that I don't have to pay until 90 days after delivery and that I can resell the goods in between. They're fundamentally different things. How do we work that out? What's material? What's important? Based on, it's not new. Jack, I can see your mind turning there.
I think they just ask them in court.
Ask them in court
But like, what matters to you and what do you mind changing? And
So that's a very subjective test.
yeah.
So yes, they would take that evidence. What kind of test do you think the court would apply?
objective
They'll
test.
apply an objective test, okay? It doesn't matter what you subjectively thought was important. It's amazing what's really important to you when you read the fine print on the agreement that you've never read in the past when a deal has gone wrong, even though your lawyers wrote it. It's amazing what suddenly becomes really heartbreakingly important to you. Doesn't matter what subjectively, the courts are going to apply an objective test. See, we're thinking like lawyers. So, what is the test? Is there an agreement? When and where is the offer and acceptance? How do you respond to contradictions between standard form contracts? Ask these questions. I think you get a more useful decision or more useful analysis actually out of the Australian case here. This is not the Battle of Worms case, but we tend to group them together. So this is Justice Hayden here, and the case is the Brambles case. And so in this particular decision, the High Court had to look at how do you find whether there's an agreement in the absence of any identifiable offer and acceptance. The negotiations have come. And Justice Hayden gives us this. When no offer and acceptance can be identified, it's relevant to ask whether agreement can be inferred, whether mutual assent has been manifested. That language is really important. Can we manifest mutual assent? And whether a reasonable person in the position of each of the parties would think there was a concluded bargain. Now we then still would have to pick out, and we'll deal with this when we look at the contents of a contract topics, which are 9, 10 and 11, or 8, 9 and 10, something like that. They're towards the end. We're still going to separate out this what is the bargain from have we got a bargain, but we're still applying this reasonable test. And so Brambles actually breaks it down again into another algorithm for us. So it starts by looking at the circumstances. Can you infer an agreement? So in that particular case, they had a period of time where there had been acceptance and delivery of goods. They'd been doing business in a particular way. You could infer from their conduct that these were parties who were comfortable doing business with each other. Then we ask, is there a mutual assent? So is it just one party that you can infer agreement from, or are you looking at both of them? Have we got mutual assent? Are both parties concluding the bargain? Is there a meeting of the minds? And then we look at, is it reasonable? Would a reasonable person in the positions of the parties having the same information assume that they were parties to a contract here, even if they couldn't unpick precisely what the detail of that contract was? And if we have those three things, then we have an agreement. Okay, so we're going to go back to our framework for determining agreement, which we started looking at the very beginning of last week. Oh no, it's not exactly this, sorry, I'm going to look at this first. Oh no, yeah, it's the same thing, just not the flowchart. So firstly, try and do it the easy way. Do we have offer plus acceptance equals agreement? Because if we have that, it's going to make it easier when you're solving the other problems of what are the terms of this agreement. Because we know if we've got an offer, that's a discrete thing that contains all of the terms, and it's not going to be varied by something that somebody else said. So we've got an offer plus agreement, then it's easy. We get to agreement, we've got that element sorted, and we can go on and think about one of the other elements if we need to. So that's what I would call the conventional approach. Secondly, and only if this fails, because if you've got agreement, you don't need to keep inquiring, right? Only if this fails, then you apply the Brambles Test. Now, we understand the Brambles Test better because we've read Butler tools. So we understand the context of it better, but Brambles is the Australian authority. So that's the test that you want to apply. And so really you're looking at if in all the circumstances to see whether an agreement can be inferred from the conduct of the parties, has mutual assent been manifested, and in a reasonable person's view, whether there would be a concluded bargain. So what are the key kinds of issues that you might like to think about when you're thinking about an agreement? Try to throw one slide together to pull them together. The difference between a unilateral and a bilateral contract. See it. If it's important, deal with it in the problem. Don't overthink it. It actually very rarely matters. When it matters, I think you're probably going to know, and you need to tell me about it. Because the way that we practice law is we categorise things. You don't do the mental checklist. What kind of contract is this? Is this a simple contract? Is it a unilateral contract? Is it a bilateral contract? Does it have a condition subsequent or a condition precedent? Think about those things. But if they're not relevant to the problem, I don't need to hear about them, right? You never have enough time, energy, words to give me everything, particularly if it's not an issue. What constitutes an offer? Identifying what the offer is part of your analysis. If you can't identify an offer, think about what that means. Okay? Maybe there is no contract at all. Invitations to treat. Being able to identify an invitation to treat in the wild, I think, is a really important skill here. Understand the difference between a conditional offer and an option. Now, Chef, you said to me before we haven't really covered options. Probably covered them as much as we're going to cover them. We might talk about them a little bit more in consideration, but I just want to make sure that we're all on the same page. What's an option? Can somebody give me an example of where you might see an option in the wild? Yeah, to leave an offer. It's a promise to leave an offer open.
An option needs consideration.
An option definitely needs consideration. The point is, and it's pretty straightforward, an option is a type of contract. So in order to be an enforceable promise, it needs to have all of the elements of a contract, and in particular, it needs to have consideration. And for reasons that hopefully you've seen me on video discussing, consideration doesn't need to be adequate. Okay, it just needs to be sufficient. It doesn't need to be adequate at all. Am I using that language around the wrong way? I have a tendency to do that. Sorry? The example could be labour. Labour. Yeah, and well, that is an option. We pay something in advance with a promise to pay for something to be held for you for a period of time. Leases are usually a good example. I enter into a contract to lease the premises for 3 years at X rent under certain conditions, and I then pay an extra $1 for an option that allows me to renew the lease to get a new contract, usually at different rent, and there'll be a formula for how to calculate that rent. But that means my landlord can't actually make the premises available to somebody else in that time unless I don't exercise the option by a particular point in time, because there's a binding promise. And so the option is a separate contract from the lease. When can an offer be terminated? Think about when an offer can be terminated. Short answer, before it's accepted. Sometimes they lapse. Sometimes they are held open for a period of time, but they can still be terminated unless an option has been created, unless consideration has been paid for that. Think about the communication issues with acceptance, be able to identify what the effect of a counter-offer is. So, and be able to distinguish different kinds of communications after an offer, some of which will be inquiries, some of which will be counter-offers. And a counter-offer has the effect of closing off the original offer, so terminating the original offer. Now, in commercial circumstances, that really matters because people will open up their offer again. You make a counter offer, they say no, but my original offer still stands. But if they want to walk away, they can walk away at that point. And then identify whether offer and acceptance is even relevant here. So if you can't identify an offer or you can't identify the acceptance, think about whether or not the Brambles test could be used to identify agreement, that consensus ad idem. So some takeaways here. The thing about acceptance is it's the thing, the piece that completes the formality. So we're going to talk about all of these different elements, but agreement itself all happens in this one moment. So I think of it as a kind of virtual circle. We start, or virtuous circle, we start with an offer. The offer needs to contain the terms, so we need to be able to see the consideration. We need to be able to identify that the offeror intended for it to be a legally binding relationship and that it could only be accepted by someone who had the same intention. We need to be able to see certainty. These are things we haven't spoken about yet. And that loop is closed when it's accepted. The acceptance doesn't add any of those things. The acceptance by itself is just a yes. Something's hiding behind there. An offeree, what's behind the takeaway chips there, is an offeree can't accept an offer which they're not aware of. And Australian woolen mills will push, and this butts against consideration, or these ideas of consideration. Woolen mills will also tell us that acceptance needs to relate to the offer, that the consideration needs to move from both sides. There needs to be a quid pro quo. So you can't just do something without awareness of the offer. Where the offer is dispensed with the requirement for a communication, then it needs to be explicitly said. LaTeX, Finance and Knight. And in the case of a unilateral contract where it's the offeror's fault that acceptance isn't received, sorry, I'm just going to adjust that slide. I can't see what we're doing there for a second. No, we're going to continue recording as I edit a slide on the fly so I can read my own notes. There you go. Almost made that look easy. In the case of unilateral contracts, where the offeror's fault that an acceptance isn't received, think about what happens there and think about when the postal rule applies. Acceptance, I hate that. Acceptance needs to be within the time period stipulated, needs to be unconditional, it needs to be given in the way that's required by the offer. So if the offer articulates a way for something to be accepted, it's not going to be a valid communication unless it follows that pattern. And offers can only be accepted by the person to whom they are made. So if they're made to the world, that's fine, but somebody else can't go in and accept for you. And acceptance can't be retrospective. It doesn't happen.